All right, so my name is Roberto Seda. I am owner of Seda Law Firm. I definitely want this to be informal, so if you guys have questions during this time, please raise your hand. I try not to be like the stereotypical attorney who's just very monotone or anything like that. During this time, I will give a lot of examples about some of the experiences that we've had at the firm. So I try to really focus in on. It's easy to talk in the abstract, but when I start giving actual examples of having to go through the court systems and what people experience, I think it really hits home. We are headquartered out of Oklahoma City. Here with me today, Alina is one of our attorneys, and then Shelby just got here and she'll be sitting next to her. Shelby's our client specialist. So a lot of times when people call into the office, they will get on the calendar with her to see if we can help you guys or not. So she'll be the one that kind of really assesses the situation. If people are ready to move forward with us, then they can go ahead and get signed up as a client. Sometimes people have additional questions, and that's when they get on Alina's calendar. I've been practicing now for 13 years. So a little bit about me. I grew up in Lawton, so I am a Lawton Mac grad from back in 1996. My dad got stationed at Fort Sill back in 1990, so I am a military brat. All right, so we moved around for a little bit, and I'm sure a lot of people here may either be in the military, have been in the military, or have worked out at Fort Sill. I did go to Stillwater, got my engineering degree, worked at GM. I actually did not go back to being an attorney until the age of 30 is when I started law school, and I started practicing in 2012. In 19, I actually opened up my own practice. We are now a team of 11 people, all headquartered in Oklahoma City, but with that, I do have a satellite location here in Lawton, and we're located out of the Chamber of Commerce there on West Gore. And my attorneys will either meet people here. We have a lot of probate matters, so my probate attorney's at the courthouse quite frequently, but we'll meet with people there. So if you guys decide that this is something you want to do, we can definitely meet you guys at the chamber. If you're going to be in Oklahoma City, it definitely makes things easier as far as like printing off paperwork, having our witnesses for our estate planning documents. So with that housekeeping, I guess a little more about me. I do probates and estate planning. Some attorneys decide they want to practice in family law, criminal law. That's not what I do, all right? If I were to be your family law attorney, you're gonna lose the house and the kids, all right? We don't want that. If I'm your criminal attorney, you're gonna be doing 20 years in jail, right? So that's not. I refer all of that away. We refer out probably about a half dozen cases every day to other attorneys because we really want to focus in on probate and estate planning. And now we've also added guardianships earlier on this year. So that's what we primarily do. As far as in the state of Oklahoma, if you look at my location here in Lawton, I probably have about 14 reviews. If you go up into the Oklahoma City, all of my locations have a significant number, all right? So when you add them all up, I've got over 500 reviews. So we've helped a lot of people over our time. And so, and thus far, it's all 5 stars, and not to say that we're perfect, but I think a lot of people appreciate the help that we provide. So what we're here for, and I really want to give a shout out to Fort Sill Federal Credit Union for reaching out, because I think that we are here today because you guys expressed an interest in wanting to know more about estate planning. All right, so they had me out in June. They said they sold out that event. Can you come back in the fall? And I said, absolutely. Because for me at this point, I've got a good team. I feel like my purpose is in educating and doing presentations and getting out into the public. And the team is there to help service and make sure that we get that work done for people. But I'm a big educator at this point, and so I present not only to the general public, I actually do a lot of presentations for attorneys across the nation, so I get to fly around, so it's pretty cool. But what we're going to talk about today is estate planning. All right, and I'll go into exactly what that is, but I believe that the term estate planning, who here has heard the term estate planning? All right, so most people, right? I do believe that it is for everyone, all right? I get frustrated when I hear from people saying, well, my financial advisor says I don't have $1 million, so I don't need a trust, right? That frustrates me. Or people, want to say like, well, you can just go online and get a will, and that's all I need, right? And it's not accurate, right? And I'll explain why through this presentation. But I truly believe that estate planning is one of the most important gifts that you can give to your family. All right, when someone passes away, the family's grieving at that point. And now they have to figure out what they're going to do with the house. Are they going to sell it? You've got siblings that are fighting as to whether or not to sell it or keep it. And so by pre-planning, by putting something in place beforehand, I think you're giving your family a gift. And I believe that you guys have the handout, so please take notes. But what I want to cover during this presentation, and if I've not covered it, we're going to have a slide at the very end where we'll touch on all these just to make sure I've covered them, is how to maximize their inheritance that you leave your children. All right, the pitfalls of putting your assets into your children's name, right? I hear a lot of times, I was like, well, I don't need estate planning because I added my kid to my bank account, or I added my kid to the house, to the deed of the house. And I will talk about why that may not be a good idea. I'll talk about the difference between a will and a trust. Who here has heard of a revocable living trust? All right, so about half, all right. And so I'll explain what the differences are. I'll explain a little bit about the expenses and delays that you may experience in probate. I've got one doozy that I want to talk about of a case that we're currently involved in Pottawatomie County out in Shawnee. How to keep your affairs private, right? That is something that the probate process itself is a very public process. And then how to protect yourself in the event of a disability. All right, as we get older, our mind starts to go, or you may have a slip and fall and you may lose consciousness. What can you do for those instances? So let's talk about some common estate planning questions. What is an estate plan? So if you hear people saying you should do your estate planning, what are they actually talking about? There's two components that we really, when we sit down with people, that we really want to discuss. We want to talk about incapacity planning. So we're going to ask you, if something were to happen to you and you're in the hospital and you are incapacitated for any reason, who's going to make those medical decisions for you, right? If you're nearing end of life, what are your wishes? Do you wish to remain on life support, or do you not wish to remain on life support? And then how do you want your property and money to be managed while you are incapacitated? I think one of the biggest reasons that I was here that people don't even want to address doing their estate plan is because they don't want to address these questions, right? Or the next one, they don't want to think about their demise. No one wants to think about death, right? So when I go out and I network and we're going around, and I may trademark this, I said I'm a death attorney. I am the death attorney, because I'm dealing with families who are either having to deal with death reactively because mom or dad has passed away and now we have to get access to their bank account, or proactively, people who had gotten to that point who are now saying, I do want to put a plan in place and we want to use you to help us get there, right? People postpone doing their estate planning for many reasons. Oftentimes when they lose a loved one, that prompts them to come in and start that conversation. Sometimes it's turning 60. I think in April, I probably had 3 consults in 1 week where they all, husband and wife, turned 60 and they're like, well, I guess it's now time to do it, right? And so whatever it is, I'm glad you're here, right? Because I think that you guys are now trying to start at least considering, is this something that would be appropriate for us? And so by death planning, you get to decide who's going to get your stuff when you pass away. So let me start sprinkling in some examples. Death planning. earlier this year, I got to work with a family out of Norman. And when I sat down with husband and wife, I said, when you guys pass away, where do you want your stuff to go? And they said, not our kids. We don't want our kids to get a dime. I said, tell me a little bit about that, right? I said, why is that? And they said, well, they haven't been around for 19 years, right? 3 kids, none of the 3 kids have been around for 19 years. And I said, okay. So I look at their assets and said, you've got $3 million. You don't want them? And they're like, no, right? And so we put a plan in place that says when they both pass away, it's going to charity, right? So these 3 charities that they have chosen, we got to put that plan in place. In July, the wife passed away, right? I visited him in August. I said, how are you doing? And he says, not good, right? When you lose someone that you've been married to that long, that's hard, right? So, but because he had the trust in place, he'd already done that planning, he didn't have to worry about going through probate court, right? And so they had done all their homework. And then I asked, I said, did the kids show up to the funeral? And he said, no, right? And he said, and I'm glad they did not, because had they done so, I think she would have been upset, right? So you get to have difficult conversations, but these are real feelings. Everyone's a little bit different, right? So right now, for myself, my wife and I, we initially set it up to where our 3 boys are going to get their our share in our inheritance. Up through about last year, we updated our trust, and I really wanted to cut out my middle son, right? He's the reason that I have gray hair, all right? This guy is a waste of talent is really the way that I was thinking about it about a year ago. And I said, can we take his share and just give it to the church, right? And I could do that. Now, my wife said, no, we're not going to do that. We're going to give him. And luckily, he's coming around, right? Like, he's my kid. He flunked a concurrent course at OCCC because he never turned in his homework at all. And then, lo and behold, during Christmas last year, he's like, well, how am I going to pay for college? And I was like, not us. Your job is to go to school, right? And so we sat down. I said, well, you're going to have to score 35 on the ACT, a near perfect score if you don't want colleges to consider your GPA, which you screwed up, right? So that's what he did in February. Scored a 35, right? I was just like, I want to strangle him because he's a smart kid. He's a good kid. He's just not he's not applied himself. And he's doing better. And had we taken him out last year because he's doing better, I would be open to let's put him back in, right? So that's the nice thing about the trust, that you can make changes as life happens, right? And I truly believe that my family in Norman, had one of those kids even come up at any point, that they probably would have given them something, right? I mean, even if it's $500,000, not a full third of their share, I would gladly take $500,000, right? I'm sure that most people here would. So having those discussions and putting their wishes on paper, I think is huge. So I get this question, what if I don't do an estate plan, all right? What if everyone here who comes today says, I don't want to do it. That's just something I don't want to think about. Well, let me just tell you, you have one already, all right? You're just going to default to what the state has, right? And if you don't like that, then you may want to be proactive and deviate from what the state has deemed. So that family in Norman, had they not done their estate planning, when they passed away, that $3 million would have gone to their kids equally. But because they didn't want that, they had to take the necessary steps to cut the kids out. The state, just so you know, will decide who can and cannot make financial and medical decisions for you, right? And that's going to be done through guardianship court. Who's going to get your stuff and when they get it, and who's going to care for your minor children, all right? Who gets your stuff and when they get it. So That's another way that you can use a trust to really plan ahead. The state says in that instance where the $3 million would have gone to the kids, if they didn't put their trust together, those kids would have inherited that at 18. My kids will inherit their share, would have at 18. We've set up our trust to where our kids don't get a dime until they're 25, and then 30, and then 35. So we're going to stagger that, right? Because I feel like I'm a pretty responsible child and responsible person, but even at 25, the difference between 25 and 35, I could see it in myself. I did a lot growing up during that time, and so we want to provide for them, but we also want to make sure that they don't get it all. So that's the nice thing about doing a trust versus what the state says, you get it all at 18. And you can imagine everything going to the kids at 18. I had one I got to work with a doctor a year ago. And what prompted her to come in is that her husband passed away August of last year. So we're sitting down in October and looking at her assets. And I said, okay, you've got about a net worth, and she's in her late 30s. She was a doctor and her husband was a doctor. They had a net worth of $4 million already in their late 30s. They had one kid. The state says that if she passed away at that point, her one kid, who was 1 year old at the time, would get $4 million. Now, the state would then determine who's going to be that kid's legal guardian, right? And then when that kid turned 18, that boy would be rolling in the dough, right? I know that if I was turning 18 and I had that much money, I'd go buy the latest PlayStation 5, right? Or whatever it may be. I would blow it. And so I think that taking that necessary step to actually put a plan in place and say, we want to give you some. So with her, what we did, he actually got 20% at 18, which is still quite a bit of money at 18, but then staggered it over 5 ages, right? So it's really unique to each client. So what is probate? Who here has had to deal with probate in the past? All right, no one's brave enough to raise their hand, all right? So probate, what it is, it's just the legal process of going through the courts to determine who gets the estate, right? So if mom and dad owned a house and they both pass away, you have to go through, because a home is called, it's real property. Real property in Oklahoma has to go through probate. Doesn't matter if the house is worth $25,000 or $2 million. All right, if it's real property, it's going through probate. Mineral interests, if you own mineral interest, those are considered real property. They may only have a value of $500, but it's got to go through probate. If you don't own real property, if you don't own your home, you're renting, if you have personal assets like a bank account or retirement accounts that are over $50,000, then you're going through probate, right? And life insurance policies, I've seen that. Yes, sir.
That's even if you got wills and all that stuff?
Well, we'll talk about that. We'll talk about can wills help, can trusts help, right? This is if you die and those assets are in your name individually, correct? So if you own personal assets of over $50,000, all right, so if you have a truck that's worth 15 and you have 35 in the bank, that's 50,000. Now you've got to go through probate, or your family has to go through probate. You have to go through the court system, all right? And so that's what probate is. And so it says you may need probate if you die owning accounts or property in your name only, with or without a will. So if you have a will, and I hear this a lot, I've got a will, I'm good. That's not the case. If you can think of a will is an automatic ticket to go to probate court, all right? Because a judge has to determine whether the will is valid or not. And the only way that you can get that in front of a judge is to open up a probate. And if you question as to whether or not a will, if it's really necessary, let me tell you about my Pottawatomie County story. So we open up a probate in May. We get an initial hearing in June. And at this hearing, we presented to the court that father died with no spouse, and two sons. So we represent the two boys. We put that in our pleadings. We file our probate. We have an initial hearing. That was on a Monday. On the Thursday beforehand, the surviving living girlfriend files a will, leaving everything to her and nothing to the boys. So we show up on Monday, and the judge is like, I'm not going to entertain this today. We're going to have to hear this a month later. So we go to the end of July. And the boys are adamant there is no way that he filed this will. And so we start asking questions. So July comes, we tell the judge, we need 2 months to do our due diligence to figure out whether or not this is a valid will. And the judge says, well, on its face, from what I'm looking at, it looks to be valid. So I'm interested to see what you find out. We had our hearing the end of September, and we had a motion. Basically, the evidence that we provided was that not only was the will not valid, it was actually forged by the surviving girlfriend. All right, so this is public record. That's why I can talk about it now. I couldn't at the time. What we alleged, and the judge granted to us, was that our person, dad passed away in April. Girlfriend in May, the end of May, went onto freewill.com using her email address, created a profile for herself and for the dad that passed away, and drafted this will. All right, in that we have a statement from freewill.com. We have a statement, an affidavit from the engineer working with them saying everything she put in is in the output, which was presented to the court. So we're tying all these things together. And then, but there's a notary saying that the notary saw the dad sign this, right? And that there was 2 witnesses. Well, we called up the notary. The notary said, I didn't notarize that document. So that was damaging to her case. And then the witnesses we could no longer find because the addresses that were on the will were her previous addresses from when she lived in the Tulsa area. So on its face, had it been presented to the court, if we hadn't come in, she would have gotten everything. But we made the case and we were able to show to the judge that it was a faked will. And if you can imagine, the judge was not pleased and basically looks at this lady and says, you know, that's a felony. And so when he finished ruling on that motion that we had in the end of September, she bolted. I mean, I think that he ruled, and before we could even turn around, I mean, she was gone. So, because I think she thought she was getting arrested. Whether she will or not, we don't know. The case is still open. But that's why we have to say a will does not keep you out of probate. You have to get in front of a judge because you have to figure out, is it valid or not? So, but probate, that court process determines whether or not you had a valid will at death, if you had one signed, who's going to be appointed to wrap up your affairs, and then who's going to receive those accounts and property. The downsides are that it is expensive, time-consuming, and a matter of public record. Expensive, we are about over $30,000 right now on this probate. Right. So we talked about how do you maximize your inheritance, what you're going to give to your kids, by keeping it out of probate, where people are going to fight over money, right? And it's going to drive up the cost. I believe that the most expensive probate I've personally been involved with, or at least for part of the time, is a probate case about 4 or 5 years ago. When it left my firm, we had billed about $47,000. That was about an $87,000 probate when it was all said and done. It is time consuming. There are some probates where I get calls from people saying, can you help us close out our probate, our mom's probate from 2007? All right. So if people are fighting, that can definitely, it can be a multi-year process. And a matter of public record, I was able to talk about what I just did because you can go online and see those pleadings, right? There was one holographic will. A holographic will is one that's done completely in handwriting, right? So there are ways that you don't have to go online and create one. You can create a holographic will, which is handwritten, signed, and dated. But we had one that we actually presented to the court, and the mom left her son $10, and he says, "This is the last beer I'm going to get you. All right, good luck." And didn't give him anything aside from the $10 for that last beer. And it makes you question what was going on in that family that led to that, right? So, all right, so can I simply avoid probate by adding someone as a joint owner? All right, so this is one of those solutions that we see, is if I die, to your question, if I die, if there's a joint owner, in that situation, no, that's going to go all to the joint owner, right? So you can see that with bank accounts, you can see that with your home. What you need to know, it is a solution, but is it the right solution? Because let's say you add your kid to the title, of your home, to your deed, and then they get into some trouble with their credit cards, and now the credit card comes after them and has a $20,000 judgment against them. They can now file that and attach that to your house, right? And so now your house is subject to this judgment that was your kid's fault, not yours, right? So that may not be something. A joint owner is also a co-owner. So that means that if you want to turn around 5 years later and you want to sell that house, you can't if your kid doesn't join. So if you severed that relationship, things have gone wrong, and they don't want to, now you're back in court saying, we're going to force the sale of this house, and you're going to have to split those proceeds 50-50 with your child. So and I've seen this before, where boyfriend and girlfriend buy a house together and then they break up. And now the boyfriend or the girlfriend wants to sell it and they can't because the other one won't sign. So there are downsides. There are ways to get around it, but there are repercussions that you have to be mindful of. There's a thing called a payable on death or transfer on death, right? So especially with homes, transfer on death deed is something that you can definitely do. It's got its plus and minuses. I'm not a big fan of a transfer on death deed. Basically it says that when I pass away, I want my house to go, and then you name somebody to receive your house at that point. The downside to that is that person, so if I owned a home and I gave it to my son, my oldest son, he would have 9 months to actually file an affidavit saying, I want that property. And if it doesn't, it reverts back to my name, and then we're going through court. And you would think that people would know that, but they don't, because I've seen it on multiple occasions where that beneficiary actually did not file that affidavit within 9 months. There's a lot of other things, but just know that it is a possible solution, but there are better ways to do things. You can have a payable on death. So let's say you have your bank account and you say, when I pass away, I want my oldest child to get it, right? I had a probated life insurance policy a couple years ago, $75,000. That's all that she owned at the time. She had done her estate planning, but failed to change the beneficiary on her life insurance to be the trust, all right? So what I need you guys to know is that once you create the trust, that's part one, all right? Or even when I sit down with people, I say estate planning is 3 phases. Phase 1's what you're doing right now. Having that conversation with us or whichever attorney you guys decide works well with you, all right? Once you become a client, and now you're into phase 2. Phase 2 is working with your attorney to create your estate plan and create your trust, all right? It doesn't stop there. Phase 3 is now where you actually need to take all of your assets and put them into the trust. So the analogy that I heard is your estate plan is like a U-Haul van that's going to go with you wherever you go in life. You get to buy a U-Haul van. Congratulations, all right? Now you have all this stuff in your home that you need to take from your home and put it into that U-Haul van, all right? And if it's not in that U-Haul van, then it's not in the trust, and it's going to be subject to going through court. So what happened in this lady's case, life insurance policy, $75,000, it had to go through probate because the life insurance company says, well, there is a beneficiary, all right? So you have a payable on death designee. There is a beneficiary. Let's find a daughter. Well, daughter had died before mom did, and that never got updated. And that's not uncommon to see even with bank accounts, where you name somebody to get it when you pass away, but they actually died before you, so there's not a living beneficiary. All right, and some people remember to update that, and some people don't. And for those that don't, that's when we're getting those phone calls to now go through probate. All right, so what are some common estate planning solutions? So I keep talking about a revocable living trust, all right, because I feel like this is the gold standard for the way to avoid probate. If you have a trust, whatever you put into that trust does not have to go through probate, all right? So this circle is the Smith Family Trust. What my wife and I have done, we've created a trust. We manage our trust, all right? We've set it up that when one of us passes, the survivor will continue to manage that trust. When we pass away, right now my father-in-law is our successor trustee. So my father-in-law is in charge then to look at our trust, and your trust is basically a set of instructions for your successor to read and say, how would Roberto and Becky, who's my wife, how would Roberto and Becky want their assets to be distributed? So you name, you're the trustee, you're going to name who's going to manage your trust after you pass away. And then in your trust, who gets your assets are your beneficiaries. Initially, that's going to be you. All right, so you get this trust, you put your assets into the trust. Let's say you change your bank account, so it's now owned by the trust. That doesn't mean you can't have access to that money. You can just write checks, you can put money into the account. Nothing changes from that standpoint, right? When you both pass, when the grantors, so the grantors are the people that made the trust, when they both pass, if there's multiple or if there's just one, when that one grantor passes away, then you figure out who are your beneficiaries after you pass away or you and your spouse pass away, and who's going to get it, right? So in the case of that Norman family, the beneficiaries are not going to be their loved ones, right? It's not going to be the kids. It's going to be the charities who are going to get that $3 million. They've named a corporate trustee, because oftentimes what parents do is when we pass away, we want our kids to take over our trust and distribute. Well, we didn't have that with them. So I said, I think in this case, a corporate trustee may be a good entity to take over and manage your trust, especially at $3 million, right? The kids are going to be fighting and coming in trying to get whatever they can. So this corporate trustee are just companies. Here locally, I know that Arvest has a trust arm to them. But in Oklahoma City, there's Trust Company of Oklahoma, there's Invest Trust. So I get to build these relationships and know which ones I feel comfortable in suggesting. So, you get to have this discussion. Who's going to manage your trust and who's going to get your stuff? But that successor trustee, corporate trustee, is going to be in charge of making sure that $3 million or whatever's left over, because they're still the beneficiaries while they're alive, right? So if he wants to go take a cruise around the world for a couple $100,000, he can still do that and access his money. But when they both pass, then it's going to the charities.
Question.
Yes.
Is there any tax liability, and also what about equity? You say it's $3 million, but the true value is $3.2 million by the time someone starts accessing it.
Yeah, so we're not worried about tax consequences unless you're going to be over 13.99 million. And in my practice, there's not a ton of people that are going to be having to worry about federal estate taxes. All right. Oklahoma does not have estate taxes as of 2010. So the only thing we're looking at is, are there federal consequences? Now, there are income tax, right? So if they were working until they passed away, there's some tax returns that need to be filed through that time. But is there a tax liability? No, not from what we're talking about, right? So you just need to know that your trust is also going to have your Social Security number as the employer ID, right? So you're still going to file taxes every year normally. My wife and I, we forget that we have our trust, right? My checks are still in my name individually, but some people get new checks and it says, you know, the Roberto and Becky trust or whatnot. So, but no, there's not really any tax consequences unless you're going to be up in that upper echelon, and that's highly advanced. But for most people, it's not. Does that answer your question?
Equity.
Oh, equity. All right. So equity, no. Again, most people are going to benefit from this. What I do find out, or do I hear, you know, let's say someone passes away and their home is $300,000, but they have a $200,000 mortgage. You've only got $100,000 in equity. We still have to list that $300,000 as the value of the estate. So we're looking at the gross number when it comes to probate. When it comes to estate planning, we're not really worried about equity, but when it comes to like the probate side, that will determine what options we have as far as probates. So there's a regular probate, and in some cases you can do a short probate, but those are only if the estate's under $200,000. We can possibly do one, because in that instance, then we also need all the kids to sign off, and we can't always get that. Right, everyone needs to play nice, and we've seen a lot of cases where they don't. But so they look at the gross estate on something like that.
Thanks.
So what's going to go into the trust during your lifetime? It's going to be your home, your real estate, your bank accounts. All of that can be retitled into the name of the trust. What does not go into the trust is your retirement account. So you're talking about tax consequences. When it comes to your retirement account, you're actually going to name your beneficiary to be the trust. All right. If you were to retitle that retirement account during your lifetime, then you're going to trigger some taxes. So we don't want to do that. And then depending on whether you're married, we're going to advise that your retirement account actually names your spouse first and then the trust second. Because if you were to die and your spouse is still living, you can roll that over, all right? And then once it goes into the trust has 10 years to withdraw that money. So we don't want to start that 10-year clock until the absolute latest. And these are the things that I think working with an attorney, we can help explain a little better than going online, who are not going to be able to factor those things in. Life insurance is another one. The life insurance, we're going to name the trust as the beneficiary. All right, so the policy maker, the life insurance company will not let you retitle that into the name of the trust. So what does this accomplish? When you pass away, you've got your successor trustee who's in charge of distributing everything to the beneficiaries, all right, who it's going to go to. And the ultimate goal is that we're going to avoid probate. All right, we do not want to have to go through probate. I want you to remember this number, 5,000. That is, when I get a call for a probate, that's more than likely the initial retainer that I'm taking. We were having a meeting yesterday at the office, watching a video, and we get a phone call, and someone needs to sell their brother's home. All right, so he needs some help. We've got to go through the probate, and Shelby was able to walk them through and get them signed up and take a $5,000 payment, because that's what it takes to get started to do a regular probate. So $5,000. So you can either, and the only people that win at that point are the attorneys, and that's coming from an attorney. And I would rather do estate plans and help families feel satisfaction in having put a plan in place than to go through probate court, right? Because it's just wasteful. So my undergrad's in engineering, right? I like efficiency, and it's not efficient to have to go through probate court. So important reasons If you've got minor children or you have kids that have minor children, through our documents you will actually be able to nominate a guardian. All right, so if you don't want your mother-in-law to get the kids, if something were to happen, nominate a sibling or your favorite sibling. So we do that through a last will and testament. Now let's talk about that, because I just said we don't want to have a last will and testament, and I'll tell you why we still do one through this process, but that's where we currently name the guardian. The child, until they turn 18, become a legal adult, just know that if something were to happen to you or your children, they would have to go to the courts to have somebody formally appointed to be a guardian. Protecting your minor child's inheritance. So minors can't own accounts or property. Your guardian will manage those assets. The probate court will be involved, right? So anytime that I've got to open up a guardianship and help somebody through that process, it's $3,000. That's the initial retainer that I take. Again, we talked about that minors will get everything at the age of majority, which is 18 here in the state of Oklahoma. And that's why a trust, really, the trust can say, well, my kids are minors, here's what I want to allow them to get. There is language that we put into your trust that says that takes care of their health, education, maintenance, and support, right? So if they get sick, the trustee is allowed to pay for those expenses. If they want to go to college, they can pay for those expenses. If they're in cheerleading and we want to help them through that process, or playing sports, we can give the trustee the discretion to pay for those costs. Sometimes you want to help so other people, right? Sometimes we want to help people that are bad at managing money, right? So just because your kids are adults doesn't mean that they ever have to get their assets, their outright share. And this one really came into play a couple of years ago when a person came to me because she wanted to get her own powers of attorney put in place, but she wasn't going to pay for it. Her mom's trust was going to pay for it. And as I try to get more information on that, what had happened is mom created a trust and her share remains in trust until she passes away. So her mom never wanted getting her full inheritance, because I guess she thought she would just squander it, right? But as far as support, powers of attorneys are important things to have in place, and so the trust company was able to pay for that, right? But just know that if they're bad at managing money, maybe you don't want them to ever get their share outright. You want it to stay in your trust. Individuals with outstanding creditors and debts, if they've got a lot of debt, maybe you don't want them getting their share. A person who carries whose occupation carries a high risk of lawsuits, doctors, maybe you don't want that. And then an individual who could end up in a divorce, right? Maybe you don't want that daughter-in-law, that son-in-law getting half of your kid's inheritance. You can keep it in trust so that it never has to be equally divided in Oklahoma, right? And depending on everyone's situation is different, right? No one here may be faced with these, but if it's just things to think about and things that that's where I think the value of working with a law firm that can give you ideas and deals with this day in and day out, it comes in, is very important.
I have a quick question.
Yes, sir.
Say you have a son that's like that last slide shows, is bad on spending money and
Yes, sir.
saving money and whatnot, and you have a trust. Can you put, like, I want to give him $5,000 per year until the trust is empty?
Yeah.
Can you do something like that?
Yeah, you can. And this is where I feel like the trust basically takes what you envision, what your ideal scenario is, and we put that on paper, right? So if you only want to give them $5,000 a year until then we can put that on. You know, that's a good way to manage and stretch that out.
Okay.
But yeah, we can do something like that.
I have a question.
Yes.
So like how he was saying about that, could they put something in writing, like for them not to have access to that money until they take a financial class or something?
You can. You can. I've done it to where some parents are like, we don't want them to get their share until they're 25. But
Make them work.
if they make them work, right? But if they complete a 4-year degree, then they can get their share at that point, right? So if they get it done at 22, they can get their share, 3 years early. So it really, that's a part of my job that I enjoy, sitting down, and for people who have those concerns, easing those concerns by like coming up with brainstorming ideas of like what is a workable plan that is would work for you. And so yeah, you can definitely put something like that. Yeah.
I have an aunt in Texas that put in her will that if anybody disputed it, they would get nothing.
Yeah.
Is that, I don't know if that's legal or not, but that's what she put in there.
We put language like that, but not only in our will, but our trust. So if someone tries to contest the trust, then they get nothing. So, so that we do put language like that in there. I saw a hand somewhere back here. Yes, ma'am.
Once you establish like a monthly amount to go to an individual, can you change that?
So the trust itself is revocable. I mean, you can revoke it if you want to rip it up and say I want to revoke it. But it also allows you to amend it at any point, which is how my wife and I initially set up our trust, and we updated it last year. And we can continue to make changes. If you are married, we can even set it up that when the first spouse passes away, we can take half of it and freeze it, but the other half is amendable by the surviving spouse. Or we can leave the surviving spouse with full discretion to modify the whole, right?
Say someone has a medical condition and you have to pay medical bills, and it reduces the amount that you wanted to leave them.
Right.
You can change
You
the
can.
amount that you leave them.
Yeah. Yeah, and it's only going to apply to what's left in the trust, right?
Okay.
So if the trust says, hey, we want to leave $100,000 to our kids, but there's not $100,000 in there, then they're not going to get anything, right? I've heard some people have said it is my goal to leave my kids $0 because I want to spend it all during my lifetime, right? So go on those cruises. As I was scrolling this morning, getting up out of bed, I saw an article of somebody who spends 300 days on a cruise ship because it's less costly than renting or something like that, right? I was like, put me on that cruise, right? So, but talking about a blended family, right? Yes.
Before you move on,
Yes.
I have a brother-in-law and a sister, and their twin boys are dependent adult disabled. Would I be able to do a life insurance plan on them and have the beneficiary be the trust, or is there no insurable interest because of the relationship is not closer?
I'm not sure if you can take out a policy, but as far as you can create special needs trusts, and I've got a slide on that, that does not disqualify them. So sometimes people are like, I've got my special needs child who's getting government benefits, but I don't want to leave them an inheritance because it will disqualify them. So you can create a separate standalone special needs trust, or our trust, we can also, if it's a child or if it's a beneficiary, we can create a sub-trust, basically, that's special needs that accounts for that. So there are ways around that. I'm not sure as far as like the insurability aspect of it, because I don't do any insurance or anything like that. But if you're wanting to leave them something, you can do so with the right trust, but you have to have that in place. Otherwise, they would be disqualified from receiving benefits. So blended family is very important. You want to accidentally avoid disinheriting your children, or that's something to consider, right? And then what do you want to do with your separate property? So blended families is a lot more common now, right? I get families that each have 2 kids, right? And without planning as to the house, if they own it as joint tenants, well, if mom dies, if the wife passes away first and the husband is surviving, when he passes, then the house goes to his 2 kids, and her 2 kids don't get anything, right? So you're almost playing Russian roulette as to who's passing away first. Same thing on bank accounts.
I have a question for you. So
Yeah.
what if the house was purchased by only one person?
You were looking at the
Would it
title.
stay in that, like, forever?
So if it's husband and wife, but it's only
Purchased
titled.
before they married.
Gotcha.
And it was just that one person.
Okay, so in that case, if, let's say you owned it, you brought it into the marriage, you got remarried, you passed away, your spouse gets half, and then the other half gets split between the kids. So now, that's if if he moved in. If you truly kept it separate, then the law says something different. So, but your spouse, the surviving spouse, will get something. We need to figure out what that share is. But again, if you want to address some of your concerns through a blended family situation, your trust, we can definitely factor that in, that says, for that house, when I pass away, I want my spouse to live in it, and when he passes away, then at that point, spread it amongst all the kids, including the stepchildren, or just your kids. And so having that discussion with your attorney, what does that look like, is really important. We talked about providing for special needs, right? So just know that if someone's getting government benefits, we can protect that, making sure that they don't get disqualified and still provide them something. Maybe we want to leave them $50,000 so that they can get a wheelchair or get their house modified, whatever it may be. We can definitely do that. If you own a business, just know that your business itself, if it's in your individual name, will potentially have to go through probate. And if you do it, that's a whole separate conversation. There's like, what we're talking about is for your personal side, for your personal life. If you own a business, you have to have your own business planning. All right. So if you pass away, who's going to manage that business? If you have a partnership, you know, when someone passes away, what does the surviving partner have to give to that family? Right, so these documents really incorporate that. So, and if you're the sole owner, who's going to run it for you? Are they going to have to sell it? Do the kids want it? Do the kids not want it? Right now, none of my kids want to be an attorney. I don't know why. Right? And I'm trying to convince them. I said it's a great life. I really enjoy it. But they're like, they want to pave their own way, and go there, and blaze it. But well, let's see, but through that, through your business documents, you can say who gets what also. Maybe an employee wants to buy it.
But does the business have to have its own planning?
It does. It really has to be incorporated into their documents. So like for my law firm, I have an operating agreement for my LLC, right? And so with that, when I pass away, and oftentimes what I've seen is we have families that have their personal life, but they own rentals, right? So, and I never advise owning your rentals in your individual name. So that's when we really get to help families put it together an LLC to own the rentals, right? And in that LLC, we say that when, like in my case, Roberto and Becky pass away, whoever is our successor trustee in our trust will manage our LLC to then distribute out, right?
But the LLC is separate from your
It is.
Trust.
Yes, it is. So that's, and again, if that's your case, we can definitely advise as to what we would suggest in that situation. But anytime that you have business operations, especially on on rentals, some people want to own it in their individual name. And let's say you have 5. All it takes is one lawsuit at one of those rentals, and now they're coming after the other 4 rentals, and then your personal assets, everything that you worked, right? So trying to create that separation. My wife and I currently own 4 rentals, and we feel pretty good that if anything happened at any of the ones, it's not going to bleed over, right? We truly have to treat it separately. Our personal life, our personal accounts are at one bank, and our business accounts are a whole separate bank, right? So we truly try to show the government that that is separate. So that's huge. Fluffy or Fido, if you've got pets and you really want to leave them something, we can put language in there. I helped a young lady in Norman, I think it was a year or 2 ago, I forget the exact time frame. No kids, not married, had 9 cats. And she wanted to make sure that her 9 cats were taken care of while they're alive. So she created a trust, right? So, and she didn't have a ton of assets, but she wanted to make sure that they were taken care of. Your trust, I mentioned that the financial advisor said you have to have $1 million. It doesn't matter. I helped somebody here in Lawton a couple years ago. She moved here from Florida, no real property, had $100,000 in personal assets. We did a trust for her because she had 1 kid, and she was like, I don't want him getting everything. And so she had a goddaughter that she wanted her goddaughter to get half. Well, has she done that in a will has to go to probate, they would probably have fought that out. But because the trust says it's split 50-50, she's going to maximize that inheritance that's going to go to both of them, right? So, but just know, even if you just have pets. This slide didn't really make sense to me because I've done presentations for years until a couple years ago when I got my own dog after 20 years of marriage, and that thing is the most spoiled thing in the world. She's pretty sweet, but I will say, and I'm not sure I've said that in a presentation before, is like anytime she gets mad, she comes to my side of the bed and she has accidents, right? I was like, you can't have them anywhere else in the house, it's on my side. So I don't think she really likes me. So other important documents, and I know we're coming up on time, so I appreciate everyone. Pour over will. This will says, if you do not get an asset into the trust, this special will says it gets put into the trust. It still has to go through probate, but there's peace of mind in knowing that your trust is going to distribute your assets, whether you put it during your lifetime, whether it's a beneficiary, right? Or if you miss something, the will put it in there. So the family in Norman with the $3 million, if they fail to get an asset into the trust, their pour over will would make sure it goes into the trust and that their kids do not get a dime. So just know that that's there as a safety net. We hope to never have to use it, but it's definitely there as a safety net. Your powers of attorney, these are documents if you guys were incapacitated, someone needs to make medical decisions, write checks on your behalf. If there's not somebody appointed through a power of attorney, you're going through guardianship court. Again, guardianship court with us starts at $3,000. Getting your powers of attorney is, even if you do just that package with us, saves your family time and money, all right? Because it's going to be a lot less than $3,000 to get those put in place. We're talking about finances, we're talking about medical, all right? Does not have to be the same people. Maybe you've got multiple kids and one's better at managing money and then one's better at making medical decisions, right? You get to decide, and I always, in all these instances, I like 3 decision makers. So that if something happens to the first one, there's a backup. And if something happens to the backup, there's another backup. And so the backups may never serve, but just know that there is that, you're just trying to be redundant in making sure that we don't ever have to go to court, right? A living will, that's your advanced healthcare directive. If you're on life support, do you want to remain on life support? Right? For me, I want my wife to pull the plug. And I'm gifting her that by saying, that's what I want. You don't have to wrestle as to whether or not to keep me on life support. So by putting that on paper, it's really a gift because they don't have to worry. And I know that if my parents were in that position, I probably want to keep them alive, but they can say no. And you can always update these, but get something in place now. I think it's important. So last slide, we talked about how to maximize the inheritance to leave your kids. Keep it out of probate court, right? Don't let your family suffer that $30,000, $40,000, $50,000 probate bill. On average, an uncontested probate, so if they did get along, in Oklahoma is $5,000 to $6,000 for a regular probate, all right? If it's a shorter one, you're still looking at $4,000 to $5,000. If you're selling property through the probate, maybe the family wants to sell it because there's a mortgage, it will be more expensive, but that's usually the bottom. I tell people, just know that $5,000 seems to be a floor anytime you go into the courts. If you put assets into your name along with your children, just know you're subject to their creditors. If you want, and they could also drain. I did get a call one time where daughter got added to the bank account and she drained $35,000, right, and took it away from her mom. And she had no recourse because she was a joint owner. So the difference between a will and a trust, a will, you still have to go through probate. A trust keeps you out of probate as long as your assets are owned by the trust. How to avoid expenses and delays of probate, that's by doing that trust and have everything in that trust. Keep your affairs private. Your trust does not have to be filed with the court, does not have to be filed with the county clerk. That's your own business, right? You can change it. And so, and I also get, the question of like, well, my mom had a trust, can I force them? I was like, well, unless you're a beneficiary, you've got no recourse, right? So, whereas probate is very public. You have to file all those pleadings. People can go online, people can go to the courthouse and get copies of those pleadings. And then how to protect yourself in the event of disability, that's by having your powers of attorney. If you're disabled and not conscious, you need to appoint somebody to make financial and medical decisions for you. All right, so what should you do?